I'm Ken Kratz, and this is Off the Record. I served as lead prosecutor in both the Stephen Avery and Brendan Dassey cases in 2007. From the time I was called to the Avery Salvage Yard on Saturday, November 5th, 2005, until this very moment, I've been gathering facts to first present to the jury, next to combat the deception in the media that was making a murderer, and finally to present to the general public in this series. These are the prosecution's stories. Although 3 separate 10-hour docu-series have devoted themselves to the topic, this is the first you will have heard from the prosecution. From me, the one who was in the room for all of it. 30 episodes discussing the Stephen Avery jury trial. Off the Record was created out of necessity. Threats and vitriol and personal attacks have become so bad after making a murderer's release in December 2015 that it led to me losing my private law practice. That's right, because of my appearance in a Netflix TV show, I lost my ability to practice my profession.
Words of what the intent is. I'm not here.
My intent was we have a discussion group, the Brendan and Stephen group.
Yep.
And we were talking about Ken Kratz.
Yeah.
And then I said, well, I live in the neighborhood with him, and I just found out.
Okay.
So people were saying, no, you don't live by him, blah, 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 whatever. Okay. So it was just kind of proof like, yeah, well, there's the picture. And
Right.
I mean, if it was wrong to do it, I'll take it down, but...
Yeah, so here's the thing.
It wasn't anything to cause damage to him or harm or threats or anything.
Right.
But as you saw the comments after you posted it?
Yeah, the guy's got threats on him already. I'm not the one making those death threats.
Right.
And,
but the other part of it is, you put something out there and then people blow it up and say, well, literally, I'm going to go blow up his house. Well,
I didn't say that.
No, I know that.
No, that's
right.
what I'm saying.
That's what I'm
you
saying.
Provide the picture. This case here, they didn't take anything down, but they flagged it.
Okay.
Sure. Blow up a house. Okay, we better.
Yeah, she shouldn't have said anything like that.
Right.
But nonetheless, yeah,
right.
I will definitely.
It gets to the point where I know people's feelings on the whole. It's a hot topic issue, and some people are just so consumed by it that they just lose their minds. You know what I mean? They just can't get on with life without thinking about.
The book I wrote on the subject was All But Silence, and I learned what it really meant to be canceled. I returned to social media in the spring of 2024 after a 4-year absence, only to find that very little had changed. I was still being attacked by internet keyboard activists, of course, but now it had extended to the attorneys who've appeared throughout the case. Jerry Buting and Kathleen Zellner seem to have taken great joy in disparaging my work and even my personal veracity and whether I ought to be believed or not. I'm not a victim. I never have been. I will never act like one or seek sympathy from anybody in the public. But I will not be silenced. This series is intended to push back on the case critics and social justice warriors convinced that the 2 innocent men remain in prison because of my corruption. These are amateur videos put together by me personally. I apologize for the low production value, but I believe the real stories need to be told as best that I can tell them. Please join me now in learning about Avery, Off the Record. This is the Ken Kratz Trial Diary. February 5, 2007, Day 1 of jury selection. This journal, recommended by former Milwaukee County DA E. Michael McCann, who is the prosecutor of serial killer Jeffrey Dahmer. Mike told me he always regretted keeping his thoughts and experiences in his head instead of on paper. This journal will attempt to summarize my journey through the prosecution of Stephen Avery, Manitowoc County case number 05 CF 381. To try and recreate my life for the last 15 months, since November 5, 2005, the day Teresa Halbach's vehicle was discovered on the Avery salvage yard property, and I was appointed special prosecutor, would be futile. I don't know if I ever will attempt to put those months into words, but for now, suffice it to say that every day for 15 months has been devoted to what's about to transpire the next 6 weeks, the Stephen Avery jury trial. My second chair, Assistant Attorney General Tom Fallon, took the lead today as individual voir dire began. He's a good lawyer and a good friend, and I trust his judgment on something as crucial as jury selection. 9 jurors were accepted today to be part of the final panel of 30. The process should be completed in about 3 days. I don't know if openings will be this Thursday or Friday, but it's obviously on the horizon. February 6th. Jury selection continues. We get 7 more jurors selected for the pool, meaning that we're about half done. We should complete this process by Thursday, cut down from 30 to 16 jurors on Friday, those are called preemptory challenges, and likely start the trial itself on Monday with opening statements and the start of testimony. Friday also should require an admissibility hearing for all the demonstrative evidence, including computer-generated images of the Avery property, images of skeletons to be used by our anthropologist to describe what bones were found in the investigation, computer renderings of the inside of the victim's SUV prepared by the FBI, and other summary exhibits and charts. February 7th. Jury selection continues, with us accepting 6 more potential jurors, bringing the total so far to 22. 30 are required to seat the entire jury panel. February 8th. Our jury panel was completed today, bringing the pool to 30 to put, quote, in the box. Tomorrow, our job is to each strike 7 jurors in what are called peremptory challenges, meaning that they're removed for whatever reason that each side believes necessary. That will be a relatively short proceeding, about an hour, but will be our last session in the Manitowoc County Court. I've included for your review all of the jurors' questions that were asked, and also all of the answers that were given. Time does not allow a deeper dive into each answer, but I would encourage anybody to pause the video should you wish to review the answers more thoroughly. I wanted to talk a little bit about the jury selection process in Wisconsin. In all criminal cases, a prospective jury panel is selected, leaving only the peremptory strikes for the attorneys to trim the size of the jury to the appropriate number. In a homicide case, 7 peremptory strikes are given to each side. Oftentimes, it isn't until after the trial that the attorney's strategy, that is, what kind of juror they hope to be on the case, is obvious. One of the biggest issues in this case raised by the defense was the amount of publicity the jury had been exposed to. In a case this large, the media was never going to be limited in what they reported. The question is not whether a juror knew about the case or knew about Avery's backstory. The question is, would they set that aside and decide the case on the facts and the law presented, and not on what they might have heard before. An email surfaced after the trial was over, demonstrating the defense attorney's jury selection strategy. They indicated that their jury was always going to be from Manitowoc County, that it was in Manitowoc County that the jurors knew the backstory. The jurors knew that Stephen Avery had been exonerated for a crime he had not committed. Avery had sued the county for $36 million. It was crucial that the jurors knew that backstory. Potential jurors who knew nothing about the case were excluded. Think how that is exactly the opposite of what the attorneys had said both before and after trial. That is, that they couldn't get a fair jury in Manitowoc County due to pretrial publicity. Remember, the attorneys needed the jurors to know the backstory. That brings us to juror number 52. During the deliberations, juror 52 almost caused a mistrial. Episode 27 of this series is devoted to juror number 52 and what occurred during deliberations. I should have known something about him. I note my first impressions were that he might be a hoodlum, which shows you how old I am. But because the defense attorneys were named Dean and Jerry, he likes Jerry Lewis and Dean Martin movies. He told us his wife has a trust fund, and that he was arrested for a child support violation, but his response was, mistakes happen. If at all possible, I was going to have juror 52 excluded from this jury. The jury selection process is not, however, about selecting good jurors. It's a winnowing process. It's designed to cut down a jury pool from 30, in this case, to 16. After both sides have had opportunities to shape the makeup through the preemptory strike process, a fair-minded and even jury can be created. Having said that, the state was looking for one kind of juror, the foreperson. Because this case involved a lot of science, a good deal of strategy and discussion revolved around how deliberations would play out. Once you can kind of figure out how that's going to go, the skill set in the individual that you're looking for to be the foreman becomes pretty obvious. Because there was so much information, our foreman needed to be particularly good at managing a large number and diverse items of evidence to be applied later to each count in the criminal information. What kind of life skills allows this approach? First off, people who like puzzles. This case was going to be put together piece by piece. So our foreman was going to have to imagine the entire case in broad brushstrokes and then be able to drill down into specifics on each count. Those people are managers. Those people are business owners. Ideally, it would be somebody with an accounting background. I wasn't sure any of the jurors would fit this bill, but it's fair to say that's who we were looking for. The foreman of this jury had to, in essence, teach the other jurors the system to be used to apply all of this evidence to just a few elements of an offense. So let's review how the jury panel got winnowed from 30 to the 16 final jurors. The first juror cut was number 7. She knew me and knew Tim Halbach, so she was never going to stand this jury. Number 8 knew Dassey. She was cut from the jury. Number 26 hadn't followed the case, didn't know the backstory, as 28 didn't know the backstory. 30 never heard of Brendan Dassey. He didn't know the backstory, and neither did 50. You can see then how they all got cut. Number 53 was aware of Project Innocence, knew about the science, but 53 presented that kind of juror who liked the show Law and Order. Jurors who like Law and Order or CSI will likely take an unrealistic view at crime scene response, and especially what DNA or other forensic testing might be able to show. Juror number 55 specifically recalled the defense peddling their blood vial tampering story in the media. And in fact, juror number 55 indicated he had, quote, outside knowledge, close quote, that might be true. Juror number 66 would have been a terrific juror for the state. He was cut, however, just because of knowing people involved in the search and came into the jury having been told at work, do the right thing and convict him. Number 66 could not stay on the jury. Inferences had to be made with juror number 72 and what I saw as red flags to be part of a harmonious jury. Juror 72 bragged about being a strong-willed woman and gave the example that she has given the Joan Crawford speech. As I recall that speech, it didn't lend itself to harmony. Juror 79, again, indicated that he has not been following the case closely, and so therefore he didn't know the backstory. Juror number 81 was a particularly nice gentleman, and he was a former accountant. He said he liked to play cribbage. He likes numbers. He's involved in lots of community clubs and organizations, and has even volunteered for the sheriff's department before. Number 81, my chance at him being a foreperson was quashed when the defense cut him. Juror number 87 was a former police officer. Knew a bunch of retired cops and liked puzzles, knew about fingerprint analysis and other evidence collection procedures. Number 87 scared me, and I didn't want to take the chance of him starting some conversation. Here's what they should have done. Our final peremptory strike was number 91. It wasn't that she was exceedingly liberal. It was that she was sure law enforcement held a particular bias against certain defendants. I wasn't leaving her on the jury. You will learn who the foreperson of the jury was. I will tell you that I found a business owner who was used to managing large amounts of information. After jury selection, it was time to get ready for opening statements. February 9th. Jury selection was completed. We were able to trim the jury pool from 30 to 16. I'm very happy with the makeup of the jury, including several members of the community with substantial ties, including some ties to law enforcement. This afternoon we had an admissibility hearing on the computer-generated demonstrative evidence. Trooper Tim Austin did a great job, and the judge ruled that most of the evidence will be admissible. This afternoon I also met with Karen Halbach, the victim's mother, who agreed to allow me to hold Teresa's St. Christopher Medal as part of the trial. I feel very comforted that a symbol so important to Teresa will be with me throughout the trial. Frankly, on those occasions that I feel a need for additional support, having a part of Teresa with me will be nice.